My Lord, thank you for the time over lunch. I can just take 2 minutes on the special arrangement, and then Mr. Hussain is going to use our remaining time. I've made the submissions on the propriety of not disclosing the special arrangement in our case at 1750 through to 1753. But this is the non-disclosure, if they are indeed conclusive evidence, which they are capable of being under 8.5 of the Act, then a fortiori, the Attorney General should have permitted submissions at the authority to proceed stage for the reason identified by Lady Clerk of Culton in the Dean case. If there is an obvious and serious gap in the specialty arrangement, which there was in Dean, and she comments on at page 5011, then if they've been filled by a separate arrangement made after the treaty has been concluded, it is essential for the court to consider how the treaty is abrogated or dealt with in order to determine whether the gap in the treaty has been successfully closed or not by any subsequent arrangements. And that's what needed to be done here. If the Attorney General, by seeking to make a further arrangement in relation to specialties, acknowledging that Article 14 is too wide, one has to see, and he should have permitted us to make submissions on whether the attempt to bridge the gap has been successfully achieved, rather than rely on the conclusive evidence clause to prevent any scrutiny. So I was going to hand over now to Mr. Hussain, who's going to deal with the Constitution.
Can I just ask
yes,
one question, and that is, what precise test are you suggesting that we might apply in determining whether the Attorney General has acted outside his powers? Is it simply on your submission a question as to whether the powers go beyond what was permitted by the statute? Is it that, or is there some discretion left to the Attorney General to which we have to apply some sort of traditional judicial review test?
Yes. No, it's the former, not the latter. It's not a question of rationality. It's a hard-edged question of law. Is this in conformity with, in particular, with the restrictions on return?
Thank you.
Yes, thank you very much, Lord. It's good to be here again. If I may say so, the thrust of my submissions would be in respect of the use of the Constitution in interpreting the Extradition Act and the attendant order. It is my respectful submission that in the interpretation of sections 4 and 5 of the Act, that a large overpowering principle are those principles contained in sections 1, 4, 5, and 13 of the Constitution. Now, perhaps a good starting point before I go to the Constitution is to refer my lords to electronic bundle 4223 in the case of Othman out of New Zealand, which says at paragraph 73, the New Zealand Bill of Rights 1990 is also of relevance in this issue. Extradition involves the possibility of arrest, detention, and forced removal from New Zealand. For that reason, rights preserved under the New Zealand Bill of Rights to freedom of movement, to free from arbitrary arrest and detention, and to natural justice engaged, etc., etc. Now, we say that the Constitution is the overpowering instrument which will inform the interpretation of Section 4 and 5. We say, secondly, and we pray in aid the principles that are set out in the case of Dean. If I may just Dean is at 4968. And I refer to just briefly 3 passages. The first passage I refer you to, my lords, is paragraph 28 at 4969. And it says, in my view, therefore, an important element of specialty is the protection of the requested person. As this court commented in Beggs and Advocate, of the specialty rule is to preserve comity between states. But comity between states is best preserved by clear arrangements, preventing circumvention of the sovereign state's power to refuse extradition where the conditions in Section 95 are not met, and avoiding the risk that the requested person, having been returned to the requesting territory for a particular crime or crimes, is there unexpectedly dealt with for other crimes. It goes on to deal with the issue again at paragraph 48. And it says, in that case, my lords would recall that there is no extradition treaty, but there's a memorandum of understanding. It says, secondly, paragraph 11 of the MU does not request the wording or meaning of the mandatory provision. So therefore, the arrangement comes in there again. And just at the end of that paragraph 48, it says as follows, that the wording in paragraph 11(1)(b) gives rise to ambiguity, uncertainty, and legal debate involving questions of constructions or nuance, renders the specialty arrangement unsatisfactory and insufficient, bearing in mind the mandatory nature of Section 9, which binds Scottish ministers. And then, finally, of course, at paragraph 67, secondly, a belief in good faith and the desire to enhance cordial relations cannot, in my view, alter the plain meaning of the MOU and the letters of assurance when properly construed. All are set out earlier in this opinion. So I tease out of that, my lords, this principle. First of all, your treaty in this particular case, which in respect of a declared foreign territory, which is monist, that is, the treaty would have passed both houses of the Congress and would be United States law, domesticated into America. And therefore, that treaty is the only instrument that they ought to rely on when dealing with someone who's extradited to the requesting state. That's point number 1. It's unlike Trinidad and Tobago, which is a dualist jurisdiction. Point number 2, because of the fact that extradition involves deprivation of fundamental rights, it involves the principle of legality, it involves the principle of the rule of law, it involves the principle of the protection of the law, one has to be extraordinarily careful about extending the scope of extradition beyond clear words spelled out in Section 4. It cannot be, my lords, that Section 4 has to be construed 4.3. An order made under subsection 1 shall recite or embody the terms of the treaty and shall not remain in force for any longer than the treaty, and the order shall be conclusive evidence that the treaty complies with the requisitions of this act, and this act applies in relation to the foreign territory mentioned in the order, and the validity of the order shall not be questioned in any legal proceedings. That provision and the consequences of that would result in the following things. First of all, it will result in an over-ambitious executive having the power to eviscerate the protections contained in the Act on all fronts: dual criminality, specialty, minimum gravity, as well as the issue of extraterritoriality. That is not an appropriate interpretation of Section 4.3, because Section 4.3 has to be informed by the requirement of certainty, by the requirement of lack of ambiguity, and it cannot be justifiable on the basis of comity. Now, my Lord, I take you to the Constitution. I know my Lord Hodge had the opportunity of dealing with quite a few of these matters during last month, I believe, when we did several of them before my Lord. And Constitution. Section 1 of the Constitution provides the Trinidad and Tobago is a sovereign democratic state. And therefore, out of that, we go beyond the principle of legality. We go to the principle of the rule of law, which includes the separation of powers. It cannot be that the legislature has delegated to the executive the power to extend the provisions of the treaty with vague and inappropriate language. Point number 2, sections 4A deals with the deprivation of liberty without due process, and there are a wealth of case law on that. All the death penalty cases, LaSalle and what, I'm not going to take much to that. 4B deals with the protection of the law, and the protection of law is dealt with in our bundle in the case of supersede. It's a judgment of the court. It's in volume 10. It's at tab 70. And
don't worry about the volumes and tabs, just the electronic.
Yeah, 4315 minutes.
I'm so sorry?
4315, I believe. 70.
4804.
Sorry, 4884, I'm told.
804.
I'm going to get it. Okay, I got it. Supersede.
4,804.
4,000. My Lord, I am not going to deal with supersede except summarize it. I asked my Lordship to look respectfully at the head note, which captures, in my view, quite appropriately what the case is about. I asked my Lords to look at 4803, which deals with Thomas and Batiste, and will deal with Maya Leaders Alliance case and the Attorney General out of the Caribbean Court of Justice. And I asked my Lord to look at the extensive quotation from the case of the Myers Leaders Alliance case. Now, the end result of supersede, which is a judgment of this court, is that if there's a law, you have a law that gives rights or protects the citizens, you must comply with the law. You can't omit to comply with it. And in our respectful submission, in the allocation of responsibilities between the three organs of government, the legislature, the executive, and the judiciary, an important interpretation device is to ensure that the executive is not given a power, albeit in a vague or uncertain manner, to go beyond the mandate which is prescribed to it in respect of sections 4 and 5. And at the same time, coupled with that, have a clause which says you can't go behind it. First of all, it is the court's jurisdiction is ousted in the light of the fact that there's a provision in section 4 for conformity. It doesn't say minimal conformity. It doesn't say broad conformity. It does not say strict conformity. The language of the act on a plain and ordinary meaning which has to be observed is conformity. Now, when you put conformity together with sections 1, 4, and 5 of the Constitution, what you get is a very exacting standard in respect of a decision, whether in the form of a treaty, domesticated in the law of Trinidad and Tobago by a legal notice, that does not allow any wiggle room whatsoever, so as to allow the executive to operate outside the parameters prescribed by it under the Constitution, and in violation of clear rights of detention and exportation of a citizen and movement out of the country. It must be clear, it must be ambiguous, and therefore, in my respectful submission, that is the principle that should inform it. Now, I say this as well, my lords. I disagree with my little friends for the respondent. This is not an interpretation of a treaty. This is an interpretation of domesticated legislation in the form of subsidiary legislation. It remains an executive act, and that authority is paragraph 3983 of Miller, the electronic bundle 3983 of Miller. It is an executive act. It is not transported, or it is not made into legislation. It is an act of the executive. And therefore, once again, if we look at section 53 of the Constitution of Trinidad and Tobago, which gives legislative powers to the legislature, and we look at the structure of the Constitution as set out in the case of Hines, what we see is the allocation of responsibility. And if the legislature wished to give to the executive a higher degree of power, it should have done so specifically. And this is why we say, my lord, there's no difference except a difference in formulation between the section, the 1870 Act, in respect of adaptations and modifications and what have you, and the formulation contained in this act, that is the Extradition Act. It's a change of form rather than a change of substance, because in determining what it means, we have to look at impact, and we have to look at what is the consequence of enabling the legislature to do what it does. A good case, my lord, is to look at Section 3 of the 1985 Act. Section 3 applies to, for example, declared Commonwealth territories, where there is absolutely no need to enter into a treaty. But what you may do is you are required by 8, of course, to do an arrangement. So therefore, the arrangement spelled out in 8 is in respect of a declared Commonwealth territory in respect which there is no specialty requirements. What is spelled out in 8 in an arrangement also is in respect of declared foreign territories where there's an omission in the treaty to have specialty arrangements. Section 8 does not allow, and I say so respectfully, my lords, the executive to provide an assurance in secret, not to disclose the arrangement, an arrangement which could violate the tenor of the Act, an arrangement, if correct, could extend the treaty as the case may be. We don't know what it says. What time was it entered? Who entered it? Who signed it? What are the constituent ingredients of it? Does the judiciary have an opportunity to test that arrangement in respect of the Act and the treaty? It does not. If we look at the case of Zane, Dean out of Scotland, we will see that the Memorandum of Understanding was the primary document that governed the relations between Thailand and Scotland, or Thailand and the United Kingdom in respect of extradition. It was defective, so they wrote a letter. The court said, no, I have an issue here. The issue is whether at all that letter could modify the principal document which governed the extradition relation between the parties. That is the issue of the Memorandum of Understanding, and that is the crux of it, quite apart from the inadequacy of the memorandum, quite apart from the inadequacy of the letter. What the court did is they went behind the document, they lifted the veil, and they determined the adequacy of it. And therefore the absence, my lords, of a special arrangement militates against this appellant, because this appellant is unable to appreciate, to know, to make representations, and to see what is it in that document which affects him adversely. Another example, my lord, is the case of Othman. We'll see from Othman the lengths to which the New Zealand Supreme Court went to make a determination, as to whether subject to allows a treaty, which is an executive act, same as the delegated legislation in this case, extend the parameters of extraditable offenses spelled out in the Principal Act. So they invoked the principle of fundamental rights in saying you can't allocate or you can't devolve an authority given by the legislature, even if the legislature does it. And what they did is they construed the word subject to in such a way as to allow the legislative parameters for an extraditable offenses to prevail, and to prevail over the treaty as the case may be. And Zentai is the same kind of thing. You see in Zentai, for example, the issue of someone charged with war crimes. And the court said, no, you can't add that war crimes afterwards. It is inappropriate because it does not fall within murder, and it is not a crime at the time when the acts were committed. So what you see out of a written constitution is a formulation and a methodology in respect of interpretation which is peculiar to a constitutional democracy as against a parliamentary democracy. Now, my Lord, I don't have the time. I think I have 10 minutes again. I just want to touch on a few issues here concerning the learned friends' arguments, and I can do so very shortly. I wish to touch, first of all, on the issue of the issue of the cases, Benjamin, my friend. And the first case I want to touch on, well, our cases as well, is Privacy International. Privacy International, respectfully, establishes unequivocally that in this particular case, the legislature, even by virtue of its conclusivity clause in Section 4 or Section 8, and the certificate spelled out in Section 8 and or Section 4, as the case may be, cannot enable or cannot preclude a court in the supervisory role from examining to see whether there's an error of law that is ultra vires. This is not a lesser tribunal as in Privacy International, and there was an ouster clause there as well. I accept the fact that you have to examine the parameters of the ouster clause, but the law is clear and unequivocal that where you have an executive authority purporting the exercise of power in breach of either precedent fact or law, the court is entitled to enter, notwithstanding the fact that there's an ouster clause. I invite you to look at the electronic bundle 4647, paragraph 144, and the judgment of Lord Cranworth. The second thing I wish to say, my Lord, is that I disagree again respectfully with my learned friends. This is not a case about proportionality. This is not a case about rationality. This is a plain and simple case, black and white, as my learned friend says. It's either it's illegal or it is not illegal. There's no nuanced analysis that should be undertaken by this court to determine whether there's lack of bona fides or there's bad faith. It is either one or the other. And I respectfully ask you not to look at the sliding scale, not to look at broad conformity. That's an alien concept. It's introduced into the lexion of the Act in circumstances which I respectfully is extremely dubious, and is an attempt to import into the Act and imply a provision that is not there. The other point is they cited the case of Rena, Briggs, and Lyons, and they're all relied upon by the respondents. We accept the fact that in the international sphere, the executive can enter into any treaty it wishes. That is never in dispute. But when it is the treaty becomes domesticated into the municipal law of Trinidad and Tobago, then that is the case where you attract the principles of judicial review set out in our Judicial Review Act, on which you can have a bifurcated approach either in terms of judicial review principles on illegality or alternatively constitutional breach, as the case may be. The next case they cited is the Central Bank of India, and they cited the Bahamas hotel maintenance case. And in those cases did not attract fundamental rights. Absolutely. There was no deprivation of liberty. There was no detention. There was no removal from domestic jurisdiction. Those cases merely dealt with a register, which required certainty in terms of its on the face of it, ex facie. And it was not in those cases as well, there was no need to determine whether primary legislation was breached, as the case may be. There was no specific mandatory direction, as in 4.2, that required conformity. And those cases, respectfully, do not provide any solace for my learned friends. In fact, in the Bahamas hotel maintenance case, the first pathway, the alternative approach, was to go to the registrar, was to approach the registrar for cancellation, and if that was refused, then you can do judicial review. And the case says that. And the second pathway is, of course, to go to the minister. And the first proposition is that EB 2761, that is to go to the registrar, and the second one is to go to the minister, EB 2752. The court acknowledged the fact that even in those cases there may be judicial review in any event. And these two cases fall into the exceptional category cases dealing with administrative operations of matters concerning the question of whether a trade union had been properly registered, as the case may be, and the other case as to whether the registry deals with the question of deeds and what have you. There's need for certainty that if you're doing conveyancing or labor relations, you have to know whether the conveyance or the document the registry produces is certain. In terms of labor relations, you have to be able to recognize the majority union. You can't be searching behind there. It doesn't include fundamental rights. So those cases fall into the category of exceptional cases as it's set out in the Halsberries. The other case relied by my little friends is the case of London parochial charities. Right? The court said no, that is an allocation of monies and resources between various charities. That is an issue for the charity commissioners. It is not an issue for the trustees. The court should not be allowed to go in and modify that again. And that is essentially an administrative or management or political judgment as to how you realize, how you allocate funds. And no judicial review in any event on large judicial review principles should be attracted to that, even on modern day principles, because of the fact that it requires the court to step into the shoes of the decision maker and make a determination as to who should what money should be allocated to which body, as the case may be. Now, the other point is, we are not, there's also an argument that we are seeking to interpret two different treaties, and a case was cited. So that is not in play in this case. And even if you don't hold that this is a statutory instrument under Section 75 of our Interpretation Act, even if you find so much, the New Zealand case is replete with the authority there that says when you look at the principal legislation, you look at the Constitution, you can look at the treaty and see what is the position. So that point goes through the window. We say Kawaja is good law. Even as a mixed issue of fact and law, the court is entitled to do that. We say, furthermore, that finally, and I'm going to close now, in my limited time, we say this, my Lord, and I say this respectfully. The reason why some countries are designated as foreign declared territories and others are Commonwealth countries, and if we look at the Act, we will see a list of foreign Commonwealth territories, and that is set out in Electronic Bundle 1919, is because we have a common law jurisdiction, and we are part of the Commonwealth, and there's no need for a treaty. And what you do is you merely make an order, and you extend it there, subject to modifications in respect of specialty required by Section 8. But with the United States, which is a moist jurisdiction, and what you do is because of the fact that in that jurisdiction, the treaty is the law. What you do, you have to spell out with some degree of precision, some exactness, some certainty, what becomes of your citizen or your resident when he's exported externally. Extradition is not a common law feature. It is a statutory set of principles. There's no extradition under the common law. It's guided by statute. What you have in the 1985 legislation, what you have in the 2004 amendments, what you have in 2003 in the UK in respect of a Category 2 country like the United States, is the issue, my Lord, of record of case. Now, the record of case, if you look at it, is a seriously attenuated process that accompanies extradition since 9/11, if I may historically look at the issue. And there's no longer a long drawn preliminary inquiry under 1870 where you give evidence and you determine what is the foreign law, and the magistrate has to make a prima facie finding. What you have to do is accept what is in the record of the case on the face value, signed by the appropriate person designated by the treaty. And that is why Farouk Waris failed, because the appropriate, my learned friend cited, the appropriate signatory did not append his signature to it. Now, in that kind of situation, where your rights are attenuated by a record of case procedure and all the attendant and concomitant restrictions which are placed upon persons, I ask your lords to determine whether the core extradition principles of double criminality, specialty, extraterritoriality, and minimum gravity should be further attenuated by giving to the executive a power to determine of its own volition a treaty which can breach the provisions of the Act as much as it wants to, without any supervision whatsoever. Allow it to have a certificate, allow it to have a conclusive evidence clause, allow out the jurisdiction of the court, and as a result of all of that, enter into an arrangement in a situation where rights are being affected in a very fundamental way. This is not an issue only about the United States. We make no criticism of what they do in that country. That is a matter for them. This court is not, as well shows. There are authorities going both ways, whether they treat people properly, they observe the treaty, or they don't observe the treaty. What happens on the face of it is this foreign declared authority might apply to any country in the world. And I don't want to be step out of line in terms of foreign relations and mention any country that is presently in breach of international. I'm not in there at all. I'm on the issue, on the face of it, whether the legislature haven't taken the care to give to the executive the power to negotiate this treaty in respect of any foreign declared territory. But then the act should then be interpreted against the background of allowing the executive an unrestrained mandate to exercise at large its powers, whether it wants to curry favor or to get aid or to do whatever it wishes in its foreign relations, and to move people around as the case may and give assurances that will undermine the human rights, protections, and fundamental freedoms contained in the Act. I thank you, Lords, very much for listening to me.
Thank you. Mr. Lewis.
My Lords, may I begin by just setting out the order of our submissions? If it meets with your Lordship's approval, I shall deal with the first three issues as set out in the Statement of Facts and Issues before the Board. That's namely the conclusive evidence and ouster clause, whether the conformity of Section 4.1 of the Act should be tested against the original Act or the amended Act, and whether or not the conformity provisions is made out. And then Ms. Scott will follow and deal with the issues of certificate of speciality and procedural fairness in the ATP. So before I turn to the law, my Lords, not much has been said about the facts in this case, and simply to assist your Lordships to navigate the papers, may I just give you the reference without turning them up of where your Lordships will find the charges and the summary of the case upon which the extradition is based. The charges are to be found at pages 1574 to 1587. The factual summary of the charges, the allegations of corruption and bribery, will be found at pages 1011 to 1067. And for completeness, if your Lordships need to reference it, the American indictment is at page 1070 to 1232. But as your Lordships appreciate, this is mainly a question of law and statutory construction in this case. So if I could first turn to the conclusive evidence and ouster clause, your Lordships have already glanced at them in section 4.3 of the Act, which one finds at page 1826. We respectfully submit that a more nuanced approach may be required than was taken in the courts below. Your Lordships will appreciate that both at first instance and the Court of Appeal, they decided to disregard the conclusive evidence and the ouster clauses. We respectfully say that that approach was incorrect. Could I just remind the board of what the courts below said? If we look at the judgment of Mr. Justice Abode and go to page 34, your lordships will see what the learned judge sets out on page 34 at paragraph 39. He sets out the basic principles about ouster clauses curtailing the powers of judicial review, and he sets out the well-known passage from Annis Minnick. If we go over the page to 35 and we look at paragraph 41, you'll see that the judge sets out what the ouster clause in section 4, that's section 4.3, seeks to prevent the review of the validity of the US order. And then dropping down a few lines, he says in the middle of paragraph 41, it is the courts that are tasked with confirming the validity of any subsidiary legislation under challenge for errors of procedural fact or errors of law in its promulgation. And he deals with the Bank of India case. At paragraph 45 and 46, which is bundle page 36, he makes this finding. The purpose of the inquiry, this is paragraph 45, is to determine the level of conformity between the treaty and the Act. It is an evidential inquiry based on fact. It is not to determine anyone's rights under the treaty. Now, in due course, I'm going to try and persuade your lordships that it's a bit more nuanced than that, that there is an element of judgment involved. It's not simply a matter of objective fact, which would lead to a precedent condition.
Ms. Montgomery indicated that this was conformity was either established or not established. In the submissions, we have examples of a very elastic interpretation of conformity. Do you agree that there's only one answer to the question of whether or not there is conformity?
Absolutely not, my lord. My lord, we say, for a number of reasons, one, say there is an element of judgment in deciding whether something conforms or not. It is not a binary answer. If it can just help, my lords, if we looked at the, to answer my lord Protector Warden's question, if we just glance at page 1826 and look at section 4.3, we do say a possible interpretation is section 4.2a is in conformity. We certainly don't say there was a binary answer to that. We in fact don't say that is an objective fact. We would say section 4.2b is an objective fact. And that, in fact, helps us give meaning if we give a narrow construction to 4.3. Because if one looks at the conclusive evidence clause, you pick it up after the first semicolon. The order shall be conclusive evidence that the treaty complies with the requisitions of the Act. Now, there was some discussion between bench and bar about requisitions. I think my Lord Hodge said it meant provisions. Well, we would agree. Because, and if it does, you can easily see that the conclusive evidence clause would in fact deal with section 4.2a in conformity with the provisions. But when one looks at 4.2b, a possible interpretation giving the most narrow construction to the conclusive evidence or ouster clause is to say that that doesn't apply to section 4.2b. Now, 4.2b is just a fact that the treaty has to provide for its determination after the expiration of 1 year. And one can see why that is an objective fact. But 4.2a has an element of judgment in it. And so, my Lord, to answer my Lord's question, perhaps in a long-winded way, we certainly don't agree that it's a binary matter. There are different interpretations of the word conformity, and it will be for this court to determine on a normal statutory construction what the word conformity means.
But having decided that, there's only one answer, is that right?
No, well, my Lord, it will have, if it has a broad construction, which is what the courts below found, the mere fact it has a broad construction itself permits of a margin of appreciation. And if one has a margin of appreciation, it doesn't permit of a binary answer. And so,
But then what's the test that one applies to whether or not the condition has been satisfied or not? I mean, if you say it has a broad construction, do you look at whether the attorney could have come to that conclusion, or it was not irrational, or is it that it's unlikely, or what is the test?
well, there is an element of that, and we do say that the Attorney General should be given a margin of appreciation. But if it is broadly compliant, in the first instance, and I think in the appellant's case, they say it is for the Attorney General to make that decision. If he makes that decision, it's a rational decision. This court should not interfere with it. And the mere fact that if the true construction is broadly in conformity, that does itself give a margin which allows it to, or prevents it from having a binary answer of whether it complies or not from a simple position. I'm fortified in that submission, my Lord, by the words in particular in the statute, that there must be some emphasis on the words in particular of the restrictions to give a distinction between what might be described as simple conformity and a more particular conformity. But if I may, I'm going to come on to that in due course, my Lord, but I'm just sort of setting out my stall on that point. But just looking at what was said below, so Mr. Justice Abode held that because it was a finding of fact, and he then relied upon the Koala case, which, if I can take it, your lordships are familiar with, that was whether an immigration official could decide if a person was an illegal entrant. And they said that was a precedent fact, and it wasn't for the immigration officer to decide, and therefore it was the court to decide. So what Mr. Justice Abode then said, and it comes to this, paragraph 47, page 37. The question is whether an ouster clause or conclusive evidence clause. He conflates them both, and in due course I'm going to try and persuade your lordships that they don't need to be conflated. One is a conclusive evidence clause, which is effectively a subset. If one was going to draw a Venn diagram, the ouster clause may include everything, but the conclusive evidence clause, we say, only deals with section 4.2a. And at the end of paragraph 47, what the judge at first instance says, I've come to the conclusion that this court will disregard section 4.3, ouster and conclusive clauses. What the Court of Appeal do is they deal with it in a slightly different way. Can I just show, my lords, that's at page 70, paragraph 10. The Court of Appeal, Justice of Appeal Smith, sets out what Mr. Mendez was saying. The respondent accepts that ordinarily a provision such as 4.3 will be construed as applying only to orders made in accordance with the law as determined by a court of law. And in such cases, the court itself would assume the jurisdiction to ascertain compliance with the law in pursuit of the evidence of that exercise would disregard the limitations of both conclusive evidence and the ousted provisions. However, the respondent contends that this general principle is not applicable here for what I summarise as the following two reasons. He sets those two out, and your lordship will see that at paragraph 14, perhaps I just point out, my lord, at page 71 at paragraph 11, where there's a court favouring a jurisdiction which does not give credence to the ouster clause. And then at paragraph 14, the Court of Appeal here, that's page 73, paragraph 14, as the trial judge found out in the present matter, the nature of the inquiry into the conformity between the US treaty and the Act is evidential, fact-based inquiry to determine whether, as a matter of fact, the US treaty conforms to the Act. And at paragraph 17, the court said, I have little hesitation to disapply the conclusive evidence provision in this case and to examine conformity. We do say that the courts below fell into error in doing that because there should be a more context and subject matter approach to the conclusive evidence and the ouster clause. The disapplying of those clauses is done in a way which doesn't take into account the full effect of the words within section 4.3. So our first submission is the determination of conformity is not an objective fact within the koala meaning, but rather it involves an element of subjective fact. This is borne out by being the words being in conformity with, or broadly in conformity, includes an element of judgment. And my lords, just to make the forensic point, a search on Westlaw, if one puts in the words conclusive evidence, you'll find that it appears in 3,280 statutes which are currently in force in England and Wales. It's not an unusual clause, the conclusive evidence. The most common example, and perhaps your lordships will know this, if we look at section 21 of the State Immunity Act, the Secretary of State can issue a certificate which becomes conclusive evidence of many facts, such as who is the head of state of a foreign country. Now, first blush, that appears to be a question of fact. Who is the head of state? But if you take, say, Venezuela, for example, some may say that Nicolas Maduro is the head of state. Others will say it's Juan Guaido, because there is that conflict there. The English courts will not speak with a different voice from the executive on those matters. And therefore, his certificate is taken as conclusive evidence. Now, of course, foreign policy issues are those subject matters where the courts usually do not tread. They're generally said not to be amenable to judicial review, such as national security issues. Now, if in this case the question of conformity is not entirely an objective matter of fact and involves some judgment, the exercise is not simply seeing if the words in the treaty are the same as the words in the Act. We would, my computer froze. It's a good job I've got a hard copy there. As I've said, we would say one can adopt a very narrow construction and say that the conclusive evidence simply applies to conformity with the provisions of the Act, which is the 4-2A test.
Why is that a matter of evidence?
Well, Well, my Lord, it's not absolutely clear why, because if he's comparing the two, and we say there's an element of judgment in it, well, I suppose the evidence is, if one has to make a decision which is part fact, the evidence which he says, this is conclusive evidence.
Well, the only evidence is the treaty and the act, isn't it?
That's right. Except, but of course, a fundamental distinction, we do not accept that this is an incorporated treaty, neither did the courts below. And I'll show your lordship, this is clearly an unincorporated treaty. It is not part of the law of Trinidad and Tobago. That was held both by Mr. Justice Abode and by the Court of Appeal. And one only has to look at the order. It does not, as my learned friend wrongly said, embody the terms of the treaty. It recites the terms. And if one looks at the order itself, perhaps we can just glance at that. If we looked at page 185, you'll see that the order says in paragraph 2, the United States of America is declared to be a foreign territory in relation to which the extradition, Commonwealth and Territories applies, following the conclusion between Trinidad and Tobago and the United States of America of the extradition treaty recited in the schedule. And going back to the requirement in section 4.3, which is on page 1826, any order has to recite or embody the terms. So here, this is simply a recitation of the terms. It has not been incorporated into domestic law. So it's an unincorporated treaty. Now that is an important consideration because your lordships will appreciate from the line of cases such as Rayner and Lyons that the courts do not interpret treaty provisions in an unincorporated treaty because they are not the law of the land. If your lordships need to, I can show you where Lyons is. It's Lyons. It's page 3884. If we just glance at that, it's in the speech of Lord Hoffman at paragraph 27. Which is a fairly uncontroversial position. In other words, the convention is an international treaty, is paragraph 27. The ECHR is an international court with jurisdiction under international law to interpret and apply it. The question of whether the appellant's convictions were unsafe is a matter of English law. It is firmly established that international treaties do not form part of English law and that English courts have no jurisdiction to interpret or apply them. And that equates Rayner. Parliament may pass a law which mirrors the terms of the treaty and in that sense incorporates the treaty into English law. But even then, the metaphor of incorporation may be misleading. It's not the treaty but the statute which forms part of English law. And English courts will not, unless the statute expressly so provides, be bound to give effect to interpretations of the treaty by an international court, even though the United Kingdom is bound by international law to do so. So, the presumption is, if it's an unincorporated treaty, this court would not construe the terms of that. So what we have here, my lords, is a slight hybrid. We don't have something which is entirely in the realm of foreign policy, which is the treaty provisions. And we don't have something under section 4.2a of the Act, which is entirely domestic. So the exercise which is carried out is somewhere along the scale between looking at matters which the interpretation of the treaty, which would be normally entirely for the Attorney General, and the domestic statute. So the course which Parliament has taken, and taken for since 1870, is to say that this is conclusive evidence and shall not be questioned in any court of law. So that is the approach which has been taken. Now, the learned friend mentioned the case of privacy, and I wonder if he mentioned the passage which was in the conclusions. So I don't think we actually looked at it. I wonder if we could just go and have a look at privacy. It's at page 4588, where Lord Commonwealth, with whom Lady Hale and Lord Kerr agreed, dealt with ouster clauses. So your lordships will see, if we go to 4588, which is, again, an application dealing with the ouster clause in the, so far as the investigatory powers tribunal was concerned. If we go to page 4647, which is the passage my learned friend identified for my lords at 144, where Lord Commonwealth, just above the words conclusions, can I just pick it up at E, when he's talking about how to construe ouster clauses. And what the majority held was, in all cases, regardless of, this is picking up from the middle of paragraph 144, in all cases, regardless of the words used, it should remain ultimately a matter of the court to determine the extent to which such a clause should be upheld, having regard to its purpose and statutory context, and the nature and importance of the legal issue in question, and to determine the level of scrutiny required by the rule of law. And my lord, we would say that that is the approach that the board should take in construing section 4.3 in relation to the conclusive evidence in the ouster clause. One has to look at the subject matter, the context, and determine the level of scrutiny which is required. The courts below simply disregarded it. And we say...
Can I just ask you a question?
Of course, my lord.
Mr. Lewis, I'm sorry for interrupting. In your submissions, I think you recognise that there may be circumstances where, for instance, the order has been made by the wrong person, or there may be bad faith associated with the making of the order, where it may be possible to look at it. But if, for instance, the order stated that on the return of the person to the requesting state, any assurance given or agreement made would no longer be binding, if that were contained within the body of the treaty, you would still say that the treaty was conclusively in conformity. Is that right?
I'm not sure I can answer that directly. You also put to me, if it said it would be disregarded.
I'm saying that if the treaty provided that it would no longer be binding on the requesting state.
Yes, that would not be in conformity.
Well, if the attorney made the order, what would happen?
My lord, that might be so within the realms of manifestly irrational, but it would come within.
Well, that's why I'm trying to work out how far are you going?
My lord, I think a year or so ago, I was on the other side of the ouster clause questions in the Supreme Court in the case of Hutchins, where the right to trial by jury, a fundamental right, had been abrogated by the Northern Ireland Order. And the Director of Public Prosecutions could say that the hearing would be heard by a single judge rather than the jury. There was an ouster clause which I attacked on the anismitic and the Perlman basis, as is dealt with here. Their lordships had short shrift of that and said that because of the subject matter and the caveat within the order, I'll show you in due course, we've got it in the papers, that the ouster clause would be upheld. So, of course, my lord, if there's dishonesty or mala fides, the court would be entitled to inquire into it regardless of a conclusive evidence or a ouster clause. it may well be that if there was manifest irrationality, if the Attorney General had gone completely mad on this point, again, the court could interfere. But what Lord Commonwealth was indicating here in the passage I've just shown you was determining the level of scrutiny required by the rule of law. And where you have this type of hybrid case, we would say the level of scrutiny is limited. The full panoply of judicial review rights would not apply in a matter such as this. And that, if one has to give meaning to the conclusive evidence and the ouster clause, it was a parliamentary intention to restrict that. Now, of course, this provision was enacted post-Anisminic, and one presumes it was dealt with in the light of Anisminic. And nowadays, we very seldom have ouster clauses. Again, a search of Westlaw says there's only about 67 left in our statutes. But one does have, in our respectful submission, to give it some meaning here. And the meaning is that there will be a limited level of scrutiny because the subject matter involves foreign policy and interpretation of an unincorporated treaty, and is really in the province of, on that side of the coin, the Attorney General's implementation of an interpretation of the treaty. He's negotiated, or the executive have negotiated the treaty, they know what it means, to a greater extent than simply looking at the words, which the court would have to do with an unincorporated treaty provision. So in laws, we do say that one has to look at this quite carefully and say, well, this isn't, we can't just say we're going to disregard the conclusive evidence and the ouster clause. We have to look at the context and the importance of the right and the level of scrutiny required. So as my lords have picked up, we concede in our written case that there are some matters such as dishonesty, bona fides, or manifest irrationality, which would vitiate the decision, and the court would be entitled to look at it. But again, it's not a binary answer here, whether the court can or can't. And in those circumstances, in this particular case, there is no allegation of dishonesty. There is no, it's not clear whether it's put as an error of law or an error of fact on whether the conformity is dealt with. It becomes an error of law if the Attorney General has misconstrued the true meaning of the word conformity. And of course, this court decides what conformity means as a matter of statutory construction. But then one has to go to the other side, and he then decides whether it is in conformity or broad conformity or in compliance, and I'll come to that in due course, with those words in the treaty. So, my lords, we do say that one has to look at the legislative history. We know this derives from the 1870 Act, which had the ouster and conclusive evidence clause in. The machinery is slightly different, but the way in which the 1870 Act dealt with it was to have general provisions in the Act. You apply the treaty, and in the 1870 Act, and a point which was put by my Lord Hodge, whether it's identical, we say it's not identical. It's paragraph 80 of our written case. We say that the words which are in section 4 are wider than those in section 2 and 5 of the 1870 Act. So and one only looks at that, and again, going back to the point my Lord Sir Declan Morgan put to me, do you have to have complete conformity? It would be very strange if you had to have absolute conformity, there would be absolutely no need to have modifications or the ability to add modifications or adaptations in the varies creating the order. It's yet another reason why a broad approach should be given to the construction. Now, my lords, the conclusive evidence clause serves a different purpose to the ouster clause. The latter applies to the validity of the order, including the discretion to make the order. Because your lordships will see the way Section 4 is structured is that there's a discretion to make the order by the use of the word may, and then there are preconditions, which are in 4.2a and b. So the conclusive evidence serves a different purpose. The ouster clause is the overall validity of the order, including the discretion to make the order, while the conclusive evidence clause, we say, only engages Section 4.2a. And that the Act applies to the foreign territories mentioned in the order. Now, this appeal is only concerned with Section 4.2a. So actually a determination of the ouster clause and the extent of the ouster clause is not strictly necessary if the board were to give effect to the conclusive evidence clause. Because in this case, we're only dealing with, we say 4.2a. However, I accept if your lordships were not to give effect to the conclusive evidence clause, it's unlikely to be saved, although it can be saved, by from a respondent's perspective, by reliance on the ouster clause alone. But if I can try and draw that to life, if we take our minds back to our school days when we had Venn diagrams, if we say the ouster clause is the big circle and the conclusive evidence clause is a smaller circle within that, so that as we're only concerned with conformity here, if it's conclusive evidence, that would be sufficient. Now, the approach to conclusive evidence clauses and ouster clauses is different. Can I just show you that? Lord, if we go to the case of Registrar of Companies at 4710, this is a decision of the Court of Appeal. And if we go to 4765, I'm picking it up in the judgment of Lord Justice Lawton at B. Your lordships have that, page 4765. At B, Mr. MacDonald refers us to a number of cases showing when judicial review can and should be granted. He placed particular importance on the decision of the House of Lords in Anna's Minnick. I do not find it necessary to review these cases because it is now, in my opinion, beyond argument that any person or body with a sufficient interest can apply to quash a decision who had breached, acted without jurisdiction or exceeded his jurisdiction or breached the rules of natural justice. However, one reads on between C and D, these well-established principles are subject to the overriding rule that Parliament can, by statutory provision, exclude recourse to the courts. The courts must, in consequence, refuse to entertain matters in respect by which Parliament, by clear words or necessary implication, has enacted that they should not have jurisdiction. My Lord, if we go to 4768, at B, Lord Justice Slade deals with the conclusive evidence clause. The formidable obstacle that's faced the Central Bank of England in making the application of reliance on evidence of this particular nature is presented by Section 78.2 of the Act, which provides the registrar's certificate shall itself be conclusive evidence that the requirements of this part of the Act as to registration have been complied with. Decisions of this court going back for nearly 80 years show that, at least in proceedings other than by way of judicial review, the court, in light of this subsection, will simply refuse to go into the question whether or not such requirements have in fact been complied with once the registrar has given his certificate. And at 4769, just over the page, D, here the legislature has, in my view, plainly entrusted the registrar with the jurisdiction to determine as a matter of fact whether the requirements of Part 3 of the Act as to registration have been complied with, and on finding that they have, to proceed to effect the registration to grant a certificate. So just pausing there for a moment, it chimes with the position here that seeing whether the requirements have complied with, and the point my Lord Hamlin put to me, well, is it really a question of fact? This part would be seeing whether it's complied with the Act is a question of fact. Although it has this element of judgment in it, it's not straightforward in our respectful submission. But certainly the intention of Parliament was to make this a conclusive evidence clause so that the deference should be given to the Attorney General. And just for completeness, at 4771...
Could you just read 4770 A to B?
4470.
4770, yeah.
At A to B. It follows that even if Parliament has used language which could be construed as meaning the decisions of the subordinate body or certificate issued by it are final or conclusive of questions on which the powers or jurisdiction of the subordinate body depend, those statute provisions will never be construed so as to include inquiry by certiorari or judicial review into questions of law on which the correctness of such determination or certificate depends. So if we pause there, I suspect my learned friend is going to say there's an error of law here, but it's not clear from their case whether they're saying the Attorney General made an error of law or an error of fact. The error of law would be misconstruing what the word conformity meant. But the fact is whether or not it complies with the statutory provisions. And of course, if there is an error of a question of law, you are clearly within anismenic territory, and all questions of law go to jurisdiction. We don't dispute that.
The passage you read out is the submission of Mr. MacDonald, isn't it?
Oh, I'm not. I think my Lord.
Preceding page.
Yeah. I'm grateful, my Lord. It's a submission, yes. He helpfully, it's at 1173 at H. He helpfully summarised his submissions.
It's adopted between you and
Right. That's all right.
My Lord, I've just taken you just to look at 117, page 4771 at B, which is certainly not in the submissions. Lord Justice Slade says, accepting therefore as I do that the registrar made one or more errors of law in the course of mistakenly deciding the requirements of Part 3 of the Act as to registration have been complied with, does this enable the court to intervene by way of judicial review in reliance on the principle anismenic? And if we go over the page, we'll see that 4772 between C and G, he sets out the provisions, and just above F, in the face of the conclusive evidence provisions, I'm driven to the conclusion that sections 95 and 98 on their true construction confer upon the registrar the power to decide finally and conclusively all ancillary questions, whether they be questions of fact or law, or mixed fact and law, which fall to be decided in determining whether the requirements of Part 3 of the Act as to registration have been complied with in any given case. So, my Lord, the submission I'm perhaps inelegantly trying to make is that one has to be quite careful in just disregarding these conclusive evidence and ouster clauses, as the courts below did, and one has to give them some meaning. And we would respectfully say that giving it a narrow construction along the lines of, as we've set out in our written case, that only in where there is dishonesty, mala fides, or manifest irrationality would the court intervene. So the level of scrutiny is limited to those circumstances, because one only has to step back a bit and see how difficult an area it is, and how difficult an area dealing with what the actual treaty means as a matter of interpretation in order to determine whether it complies with the Act. One has, because it's not, we say, simply comparing the words. It's more than that, and that's why it has an element of judgment in it. My Lord, that approach, I won't take you to take up much
There's
time.
been no case on the 1870 Act equivalent wording?
Never.
Or any other?
No one has ever challenged it. And in fact, the same provision applied in the 1989 Extradition Act. And again, that was never challenged.
Sorry, what was never challenged?
I think my Lord was putting to me whether anyone challenged those conformity.
Whether there's any case that's considered what
yes, so
requirements are.
has there ever been a case which challenged the vires of making the order based upon non-conformity?
I just wanted to be sure, yes.
And there hasn't.
Yeah.
And so the 1870 Act was replaced by the 1989 Extradition Act. And I think it was Section 4 of that Act had the same clause in it. So we have to look at the context, subject matter, legislative process, which are all important considerations of the correct approach to the interpretation of the conclusive evidence and ouster clause. Now, first, the nature of the delegation. This requires a negative resolution. And moreover, Parliament was given precisely the same material or evidence, if it can be put that way, as was before the Attorney General. The treaty, as we know, was recited in the draft order. Now, I'm helpfully informed by Ms. Scott, who's got an encyclopedic knowledge of these things, that it's Section 4 of the 1989 Act, and it's in our bundle at page 2031, if your lordships need to turn it up later. So the treaty was recited and put before Parliament, subject to negative resolution. And the fact that an order is subject to negative resolution is an important factor in assessing, with or without an ouster or conclusive evidence clause, its reviewability. I'm not saying it's unreviewable, because that's clear, but it's a factor which is taken into account, and that's what the courts have said. Can I just ask your lordships to look at the speech of Lord Scarman in Notts County Council case? Your lordships will find that at page 4132. And if we go to 4139, in the speech of Lord Scarman, picking it up at G, for myself, I refuse in this case to examine the detail of the guidance or its consequences. My reasons are these. Such an examination by a court would be justified only if a prima facie case were to be shown for holding the Secretary of State had acted in bad faith or for an improper motive, or the consequences of the guidance was so absurd that he must take leave of his senses. So your lordships will see where I've paraphrased the test I originally put in the answer to my Lord Sir Declan Morgan on that approach. And this is dealing with subsidiary legislation which was subject to negative resolution. If we go to 4142 and pick it up just above D, again in the speech of Lord Scarman, the law has developed beyond the limits understood to apply to judicial review as practiced by the courts in 1948. The ground upon which the courts will review the exercise of administrative decision by a public officer is abuse of power. Power can be abused in a number of ways: by mistake in law, misconstruing the limits imposed by statute, on the scope of the power, by procedural irregularity, by unreasonableness in the Wensbury sense, or by bad faith or improper motive in its exercise. A valuable and already classical, but certainly not exhaustive, analysis of the grounds upon which courts will embark on the judicial review of an administrative power exercised by a public officer. But, my Lord, what the impact of this case is that because the nature of the delegated legislation wasn't simply a power to do something, it was a power which could only be exercised in conjunction with having it laid before Parliament and subjecting it to negative resolution. The threshold was put higher. Secondly, the subject matter. We do say, and I don't wish to trespass on the court's patience by repetition, but we do say that the subject matter here involves an evaluation whether an unincorporated treaty is in conformity with an act. And of course, the courts can interpret the act, but if conformity with the act requires interpretation of the treaty, then that edges into an area where the courts must tread carefully. Now, in this case, the other state party to the treaty is the United States of America. Your Lordships will appreciate the United States is a monist, constitutional, common law country, as opposed to Trinidad, which, like England and Wales, is a dualist system. It follows the treaty in the United States is self-enacting or has direct effect. And therefore, interpretation by this court should not be embarked upon it lightly. And moreover, perhaps we can test the situation by this example. Where there is a multilateral extradition treaty with a variety of legal interests and diplomatic interests, how it would be strange in those circumstances if that treaty had to comply with Trinidad and Tobago law. It would just be an imposition, as it were, that everyone else had to fall in line precisely with the way in which Trinidad and Tobago had developed their legislation. And it's because of this, the subject matter, that Parliament has enacted these twin pillars of a conclusive evidence and an ouster clause. Thirdly, fundamental rights are only indirectly engaged. My learned friend has made much of this. It's simply that the order applies the act. Even if it did engage fundamental rights, we say that would not be a bar to giving effect to an ouster clause. The case I mentioned earlier, Hutchins, could I just ask your Lordships to glance at that? It's in our bundle at 3514. This was unquestionably a fundamental right. If we go to 3520, paragraph 15, we'll see the provision that we're talking about. You'll see it was section 7 of, this is the Northern Ireland Order. And there is a modified ouster clause. Your Lordship see there, no court may intervene proceedings or for questioning whether by way of judicial review or otherwise any decision or purported decision of the Director of Public Prosecutions in relation to the issue of a certificate under section 1. And then there are some caveats, the exceptions, dishonesty, bad faith, or exceptional circumstances. And what the Supreme Court said at 3532 was upholding that ouster clause because of the subject matter and, in fact, the way in which it was the subject matter and the way in which it was enacted. That's 3532, paragraphs 55, where the 55 counsel seeks to place it there by reference to what he claims is a fundamental right. So fundamental rights were engaged. But the Supreme Court said that's not enough. And at 57, quite apart from the statutory imperative requiring there be exceptional circumstances in the absence of bad faith or dishonesty, the decision whether to issue a certificate is obviously one which should not be subject to the full spectrum of conventional judicial review challenge. Unlike most decisions taken in the public law arena, it's not founded exclusively on the evaluation and weighing of evidence. So what their lordships said in upholding the ouster clause was it was a slightly modified ouster clause because it allows challenge on the grounds of dishonesty and bad faith. And we would say your lordships could read in to the ouster clause in 4.3 of the Trinidad and Tobago Act those exceptions. So the exceptions would be that it would be not reviewable except on the grounds of dishonesty or bad faith. And that would give meaning, which helps with the fact that we're dealing with something which has a negative resolution of Parliament, subject matter involves foreign policies, and the context. And in those circumstances, proper meaning can be given to it. And it's common ground that there is no challenge in this case by way of dishonesty or mala fides to the decision of the Attorney General. Can I pick this up in our written case at our paragraph 32? That's page 1772. Paragraph 32. We say the sound policy reasons for Parliament to have delegated to the Attorney General the exclusive determination of whether the provisions of the treaty are in conformity with the Extradition Act, subject to approval by negative resolution. And by doing so, control over a sensitive function of the executive's foreign policy was maintained. And section 4.3 sets out that mechanism. We set out the points in paragraphs 34 and at 37. 34, the two indented points, 34.1 and 34.2, because we don't accept that there is simply a precedent objective fact. Your Lordships, an objective fact is actually well illustrated in the Croydon case, which was before the Lordship's House. I can take you to it in a moment, but just to set out the facts of the Croydon case, that was whether a local authority has to give accommodation to a child. And immigrants had come in and they claimed they were children. And the question was whether or not the decision of whether they were a child was simply upon reasonable grounds by the immigration officer, or was it a matter of precedent fact by the court? And because there is a yes or no answer, Lady Hale said that is a precedent fact, and therefore it's a matter for the courts. And it is not a matter which simply comes into the margin of appreciation. But it's quite different. And I was pressed on the point by my Lord Sir Declan Morgan whether it's a yes or no answer. And it is possible that a different Attorney General could have a more nuanced approach and say, well, that is in conformity, when one is talking about whether this is in broad conformity. The Wheeler case, I'm simply going to give my Lord the references to that. We've set that out at paragraph 37. Because of the time, your Lordship will see that on page 1774. There was a question whether the Lisbon Treaty was materially different from the Constitutional Treaty. And the court held that an interpretation of the treaty depends on political perspective and political judgment. So, as we would say in this case, we're not just comparing the words. There is some judgment which goes into the interpretation of the treaty. And the interpretation of an unincorporated treaty, as I've shown, my lords, is not something on which the courts adjudicate. We're not comparing two treaties as in the Wheeler case. But my learned friend is, in fact, asking the board to determine one way or other of the materiality of the differences she has identified. Now, all this, we say, points to an acceptance that the Attorney General's decision that the treaty is in conformity with the Act is non-justiciable in this court, absent the concession we made at paragraph 39 of our written case, which is the dishonesty and malafide one. And so, in short, we're asking your Lordship to read down the ouster clause and give effect to the conclusive evidence clause in this case. If that be right, it allows your Lordships to give meaning to the clauses and also attacks are prevented on every order incorporating a treaty. And it will advance the objective of facilitating extradition arrangements.
Just your para 39 just refers to dishonesty and bad faith, but as I understand, you accept manifestly irrational as well.
I would, my lord. The way in which it was put by Lord Scarmer, I think, is how we would adopt it. Because an issue arises, and I know it's a point, in fact, that I think in the final question my Lord Burrows was putting to my learned friend was whether or not any margin of appreciation should be given to the determination of whether or not there is conformity with the Act. Now, if it's an objective precedent fact in the koala sense, which we don't accept it is, there is no margin of appreciation. The court just determines whether or not it's a fact. If the Attorney General has to make his own judgment, well, that's different. You then do incorporate a margin of appreciation into it because he has been entrusted with making the decision and not this court. And it's not an objective fact which becomes precedent.
Well, the words don't say if in the opinion of the Attorney General.
They don't.
But are you reading those words in effect?
Well, my Lord, my learned friend seems to accept that in her case. We do. She says in her case, just take my Lord to it, that it is a decision of the Attorney General. If we go to page 1720, it's paragraph 27 of my learned friend's case. If my Lord's using the bundle, it's tab 4, page 1720. And if we pick it up at the top of page 1720, in arriving at a decision to promulgate the USA order, the AG would had to assess the terms of the treaty and make a legal determination of finding that they were in compliance. So as I read that, that is saying that the Attorney General makes the decision. It's not a precedent fact which either exists or not, as in whether someone is a child in the Croydon sense under Section 20 of the Children's Act. It's a determination. And once the decision maker has to make a determination, we respectfully say that it's inherent that there becomes a margin of appreciation.
And in that passage, it's said to be a legal determination, so presumably the next sentence relating to error means an error of law.
Presumably, but we don't say it's a legal determination, we say it's a factual determination.
Well, you said the ultimate, the conclusion on compliance is a factual question. But in order to reach that conclusion, do you not have to analyse what the Act says and weigh that against what the treaty says?
You do. To that extent, of course, Margaret, it's a matter of mixed law and fact.
Of course it is.
Of course it is.
So it's not purely fact. But
it's not purely fact, but whether it's what the word's in compliance with is a matter of law and construction for your lordships. That's quite clear. That's a matter of law.
Yes.
If he's misdirected himself as to what compliance means, well, that's an error of law. If he's correctly directed himself what compliance means, but they say he's made...
But in any given case, you'll never be able to tell, will you? Because the certificate isn't going to set out his legal analysis.
Well, my lord, that's right. Well, that's precisely why there is, we say, a conclusive evidence and an ouster clause here. And you can't simply say there's an error of law. One would have to identify what the error of law is. And the error of law here would be, I presume, misconstruing the true meaning of the word in conformity with.
Or I suppose possibly misconstruing a provision of the treaty.
Well, Lord, yes.
It's possibly the ban on the courts construing treaties doesn't apply to the Attorney General.
But that creates that precise problem if it's misconstrued the treaty. But it's an unincorporated treaty, so the courts aren't going to be able to opine on that.
Well, the treaty is unincorporated, but the structure of Section 4 is that the effect of the order is declaring that the Act applies to the foreign territory. And the order can only be made, as we've said, that's subject to exceptions, adaptations, and other provisions. But as Lord Briggs said this morning, the order itself can only be made if there is conformity. It seems to me the fact that the order is designed to say that the Act applies and the order can only be made if there is conformity does mean that the Attorney General, at least, must be making some sort of legal analysis as to the relationship between the Act and the treaty.
I agree, my Lord. But no error of law has been pointed out to that by my learned friends on that. I agree, there must be a mixed matter of law. It's a bit like the chicken and the egg. At first reading it, you think, well, perhaps you could modify it if it's not in conformity, and then it becomes in conformity. But as my lords have pointed out between bench and bar, you can't really do that because you can only make the order if it's in conformity. Yes. But if there was some matters which were not in perfect harmony, but it was in broad conformity with the Act, you could make the order and then you could tinker with it. But in this case, there are no modifications. There is no limitation.
When you say tinker with it, it's tinkering with the provisions of the Act as applied to the order.
After you've made the order, yes.
After you've made the order.
I think, my lord, I'd have to say you'd have to make the order first.
Well,
unless my junior has got a slightly different approach on this. It may be that. Would your lordship give me that? Because you have to make the modifications in the order, it becomes. Yeah.
They've got to be in the order.
It's got to be in the order.
Yeah.
Yes.
So it becomes one act.
There's no room for subsequent tinkering.
No.
No.
So
no.
the oddity is that it seems to provide for adaptations, modifications, and other provisions of the Act in its application to the particular foreign territory. But the treaty itself seems to have to be in conformity with the Act.
Yes.
How do we square those two?
Well, I think we square it by saying it doesn't have to be, it only has to be in broad conformity.
Yes, so you're saying that the very fact that the Section 4.1 has gone beyond the wording of the 1870 Act in allowing for further modification supports your view of a broader conformity.
Exactly.
Yes.
Exactly.
But can I raise one other point with you? I mean, if the Attorney General reached a decision that the treaty which disposed of double criminality, let us say, what was in conformity with the Act, would that fall within any of Lord Scarman's grounds of excluding the ouster?
It might fall within his term. I think he used the word absurd.
Yes.
So it would fall within the manifest irrationality.
Yes. So you are accepting that there are certain building blocks of extradition that, if the treaty excluded, one could not say that there was conformity with the Act.
I think so, my Lord. Yes.
I wanted to see how far you push.
Yes, I think I have to realistically accept that there will be some areas. Otherwise, he determines his own jurisdiction, which we can't have on an anismic or Perlman view. So, my Lord, could I then just turn to the second issue, and I'll take it quite shortly. This is whether or not we should deal with the comparison between the treaty and the 1985 Act or the 2004 Act. We say, with the greatest stretch of my learned friend, her submissions are hopeless on this. It clearly is the 1985 Act. That is what both courts found below. Your Lordships have been taken to the case of Zentai, which is the High Court of Australia, says the same thing. My Lord, just putting it shortly, if on the 2nd of April 2004, when the Act was amended, on my learned friend's argument, the order becomes ultra vires because the conformity requirement is no longer met. And one only has to think of the chaos that would have if you could have an implied repeal of an extant order, effectively by a side wind. And indeed, on her argument, the same thing would happen if a new indictable offence was enacted. Don't mind an amendment to the Extradition Act, because that would change the position between the comparison of the indictable offences within the treaty and also the list in the 1870 Act. My own friend seems to have abandoned the argument which was set out in the written case on section 29.3 of the Interpretation Act. We would say rightly so, because simply, I won't take your Lordship to it to take up time, the closing words of the subsection, which deals with the continuation of or amendment of existing subsidiary legislation, is only if the provision itself is amended. So if section 4.2 had been amended, then it might have bitten within section 29.3 of the Interpretation Act. But here, it's other parts of the Act. So there is no argument, and I don't think it was put forward in oral argument on that. But we simply say, my Lord, that, and the updating construction point, again, we say, has no traction at all. The updating construction clause we saw in ZYN and Walsall, it deals with words. It's nothing to do with the vires of an order. You can easily update if an old statute talked about a trolley bus, you might now include it to include a train or a bus. But that's using the updating construction to words. It's nothing whatsoever to do with has anything to do with updating the vires of an order which has already been made. My Lord, I'm not sure I'm going to improve further on those submissions. We simply say it's clearly the 1985 Act, as the courts below found.
Well, I mean, to read into section 4.2, which says an order shall not be made, the words or maintained in force, it would be judicial legislation.
My Lord, it would. It just isn't there. And it would have strange consequences. So the courts below were clearly right. It's the 1985 Act. And in fact, that's worse for us, as it were, because they have a list schedule. In the 84 Act, we have the 12-month requirement. But I think the right answer is the answer. It's the 1985 Act. So can I just then turn in the last few minutes we've got this afternoon to the central issue of conformity. But I do want to deal with two matters which are preliminary to dealing with that central issue. Before we test whether the treaty is in conformity with the Act. And those preliminary issues are as follows. First, what is the true construction of the word conformity within the meaning of section 4.2 of the 1985 Act? It's clearly an issue of law and construction. And secondly, what should this court's approach be to testing conformity? Is it a simple substitution of the court's judgment, or does the court give a margin of appreciation to the decision of the Attorney General when the treaty is in conformity to the Act? So those are two preliminary questions. Turning to the first preliminary question. Now, my learned friend's written case at paragraph 55 in itself has two types of conformity. She says conformity simpliciter between the treaty and general provisions of the Act, and then strict conformity, whatever that degree means, with restrictions on return. My lady friend appears to argue that there has to be an exact correlation between the terms of the treaty and the terms of the Extradition Act in respect of any provision relating to the power to order extradition. And we respectfully submit that that construction is unsustainable. And it is our case that the Court of Appeal were right to hold that the phrase in conformity with, within the Extradition Act, should be given a broad statutory construction. And the reason we say it should be given a broad statutory construction is supported by four principles. First, the literary construction. Well, if your lordships now have the supplementary bundle, we can turn to the full OED definition, which is the literary provision.
Literary or literal?
Literary, not literary. Literal.
Right.
Oh, I'm sorry, Rob, I'm tongue-tied over that.
I hadn't heard of literary.
No, a literal interpretation as opposed to a purposive. Or,
yeah.
It's page 91 of the supplementary.
I think it's 91. It's right. It's 91. We've got it 5146. I don't know if your lordships go up to 5146.
As we said earlier, our electronic bundle starts at page 1 and ends at page 93.
You have to abstract.
But if you tell us, in this case, we
I think it was 91 in the supplementary.
It is 91.
Yes.
Yes.
91. Perhaps we start, if that's 91, perhaps we should start at 89. And we've got the longer OED.
No, 91's the first page.
Oh, I'm sorry,
Yes.
because I'm looking at the wrong. So 91
Yes.
is the OED conformity.
Yes.
And at A, correspondence in formal manner, agreement in character, likeness, resemblance, congruity, harmony, accordance. And if we go to 93, I think it must be, they use the phrase which we're looking at to construe in the provision, which says in conformity with. Do your lordships have that? And it says in agreement, accordance or harmony with, in compliance with. So one only has to step back for a moment. It's impossible to have a right or wrong answer to those matters, because it will be a matter of, it permits of someone having a judgment. I say that's in conformity with it, and you say it's not in conformity with it. And if one gives it a margin of appreciation, they may both be right. So if we went along in compliance with, and that reflects the language used by Mr. Justice Abode, I'll just give my lords the reference. He says at paragraph 48 of his judgment, he held that to conform is to correspond in form, nature, or character. And following that, he said it must follow something less than a precise correlation or exact transposition of terms is required. Sorry. I think that's our submission on there. And paragraph 48 of his judgment, the lordships have that. That page. Page number 37.
Sorry, which page?
It's page 37, my lord.
37.
And unfortunately, the copy is not terribly good. No. But if one looks at this middle of 4 lines up from the bottom of the page, for one thing to be in conformity with another, it should correspond in form, nature, or character. That's what he says. And the Court of Appeal, I want to say it should be broad conformity. So, looking at the literal meaning again does not permit of a simple answer. And we say, even from the literal meaning, one can have a broadly in agreement with, or broadly compliant, would still be in conformity with. It would do no violence to the words to adopt that submission. The second point on construction is that it's clear from the surrounding words of the section that conformity is to be construed as a relative term. Your lordships have seen the words in section 4 to in conformity with the revisions of this act are clarified by the further words of, and in particular with the restrictions on return. Now, if the conformity test is narrowly construed so as to mandate strict correspondence, it renders the additional words odious. By contrast, a wide construction gives them meaning. Accordingly, read as a whole, the wording of the subsection indicates that the standard for meeting the conformity test is not to be uniformly applied throughout. It can be on a sliding scale.
So in relation to restrictions, how do you say it applies?
More particularly would be the sort of answer I'd give my law. But if I use just another synonym for that, I mean, particular regard has to be paid to that, so which indicates lesser regard has to be paid to other matters. I did at first think, when one looks at it, whether they're talking about what happens on return, after someone's been returned. But in fact, it appears, if one looks at the side note in the section, the side note in the section has paragraph, section 8. It says general restrictions on return, but then does talk about the return. If your lordships look at page 1828, the side note, I know the side note's not a good method of statutory construction. I don't want to be criticised for that. I'm just simply saying it gives an indication here, although obviously side notes are not part of the legislative procedure.
Are we entirely concerned here with the restrictions on the return of fugitive offenders?
Well, the Lord learned friend would say that the if we look in general restriction on return, section 8 comes into those, and it sets out 8.1 a number of restrictions. So political offence, which is dealt with in the treaty, for example. My learned friends concentrated on 8.3, which is important to note that it's not the same as the Act in that it says a person shall not be returned under this Act to a declared Commonwealth or foreign territory or committed or kept in custody for the purposes of return unless provision is made by the law of that territory or by an arrangement. So what it's saying, it's not quite comparing the right structure. The treaty deals with specialty in Article 14 as a black letter law position, while Section 8.3 is saying you have to have that set out, a provision has to be made for it. So when you're saying, well, does it comply with that? You're not quite comparing the same things. Article 14.1 is a black letter law position on specialty, while 8.3 is saying you have to make provision for something or an arrangement. And interestingly, your lordships will see under 8.5, subsection 5, that you can have an ad hoc arrangement, as there was in this case. Again, of which is conclusive evidence of the term that the specialty provisions are comply with the Act. So, I'm sorry, Lord Barrows, I'm not sure I've answered your question there. I got slightly lost in the...
Well, I suppose it's the question really whether your point about "and in particular" is really helping your case if we're actually concerned entirely here with restrictions. It wouldn't really help to say, well, the first part of A is dealing with broad conformity because, look, in the second part, there's something talking about specific conformity.
Well, my lord, extradition crime is not under general restrictions for return. Extradition crime is dealt with under Section 7, which is not under that heading.
Right.
For example, under 5. And that is the definition of extraditable offence in Section 6. So, to that extent, we're not solely dealing with, on my very friend's case, general restrictions on return, some sort of scale.
But the whole purpose of defining an extraditable offence is to see whether something's happened which can lead to the person being returned.
My lord, yes, but there are many other...
Why isn't the definition of extraditable offence part of the restrictions on return?
Because there are lots of restrictions on return, such as...
I'm not saying it's all of them, but part of them.
But part of them, that would mean there would be no... That would mean everything would be in there, because you'd have to comply with the Act as
I haven't been through the Act with a fine-tooth comb, but on the face of it, the first question anybody asks to see if somebody can be extradited is whether it's an extraditable offence.
Well, that's probably right. But that is not technically, we would say, restrictions on return. Okay. Because restrictions on return come within Section 8. The opening words, I'm not going to rely on the side note because for all the reasons which are familiar, a person shall not be returned under this Act or kept in custody for the purposes of the return. So it's clearly Section 8 that is the focus, we would say, of those provisions. The focus is not, because for instance, 12 says you can't be returned if there's not enough evidence before the magistrate. I mean, that's one of the first things that other people would ask. So is, for that purpose, Section 12 to fall within, in particular, restrictions on return? we would say it doesn't fall within the natural language here. Restrictions on return are set out in Section 8. There are other procedures in the Act which obviously would prevent return. So, for instance, if my lords went to 5, a person, this is page 1826, a person found in Trinidad and Tobago who is accused of an extraditable offence may be subject to be arrested and returned. But one doesn't put that as a positive restriction on return. It's simply a liability to be returned. Whether that's a distinction.
As I understand your case is that extraditable offence and extraterritoriality are not be understood as restrictions on return, but lesser offences and specialty in Section 8 are.
Well, that would be the natural reading of the Act.
Yes.
It's difficult to say that one can make such an easy distinction on it.
Yes.
One has to.
But that might call into question whether, in particular, indicates
whether it adds
a different standard, a different approach to conformity at all.
It may not, my lord. It might just mean, as I hope I said. Perhaps I said inelegantly earlier, you just have to pay particular attention to it as opposed to altering the requirement of strictness in compliance. Although that does seem somewhat I don't want to say a cavalier approach to the other predictions. One has to take them all perfectly seriously. And also, I see the time. Would that be an appropriate moment until we can move tomorrow?
Yes, I don't see any immediate further questions. That would be it. We shall adjourn now and resume tomorrow morning. Thank you very much.